because I still see the mute flag on my picture, and that's why I panicked. So if you recall in the recent political engagements and activities in Brazil and Peru, I hope you'll know that how the citizens back in South America will engage in these political activities. And I'm very happy to see you, Doctor, and took this issue to this symposium. And the floor is all yours. You may start.
Thank you very much. Don't mind the pronunciation. And thank you for the presentation. And I would like to thank the organizing committee for this opportunity and congratulate for this exciting event. Special greeting to my colleagues, presenters, and the listeners of these sessions, and our chair. Thank you very much. And I will share with you a PowerPoint presentation. Just a minute. I think you can see it, right? I hope so. Okay, thank you. And just to put in this mode, that is better. That's it. And the title of my presentation today, and also the title of the paper that I submitted to the symposium, is Populism and Constitution in Brazil and Peru. And I am a professor of constitutional law here in Brazil at IBMEC University Center, where I coordinate a research project on the relationship between populism and constitutionalism in Latin America countries. That's why I was very happy to have this opportunity to present my work in a symposium that has the objective to change ideas about constitutionalism in the global South countries. I thank again for the opportunity. And this paper presents some results of this research work. The object of my paper is to study the relationship between constitutionalism and populism from a comparative perspective and analysis of two recent populist regimes in South America, namely the Jair Bolsonaro's regime in Brazil and Pedro Castillo's populist government in Peru. And why to compare these two populist governments? There are some reasons for that. First, because these two populist governments have some important similarities concerning the constitutional structure, the social scenario of both countries, and also the used populist rhetoric by these both populist leaders. But at the same time, these two regimes present also important difference between them. We'll see that despite of these initial similarities, they share some important difference regarding constitution and human rights issues. So I present to you here the two main questions of my work. The first one is how these populist governments address human rights issues. And the second one is questioning if they are successful in implementing their respective agendas under the current national constitutional structure. And in order to respond to these main problems, I will follow this structure. This is the structure of my paper, and also for this brief presentation. First, I will offer a brief analysis of the development and the main features of populism in South America. Then I will point out the relationship between constitutionalism and populism. Subsequently, I will address the main characteristics of Bolsonaro's government in Brazil and Castillo's government in Peru concerning constitutional reform and human rights issues. And as conclusions, I will answer the two initial questions of the research that I haven't presented before. My idea is not to be descriptive, but rather to present to you in order to discuss later the key arguments of each session of my paper and also the main results of my research. As methodology, I used a comparative and qualitative approach based on the specialized literature on constitutionalism and populism in South America, but also based on documents like government plans and the legislation, and also some news materials available on the internet. So the first section of my paper is about the development and the main features of populist regimes and movements in South America. And we can see that this region has presented over his history a wide variety of populisms in plural. In fact, the study of South American populism is very interesting and essential to reject a general negative perception that one can have about populism. Populism has a bad reputation, including in the academic sphere, because it is regarded to be a radical way to do politics by manipulating the population through intimidations, through some political discourse, or even by force and violence. But in practice, there are many types, many dimensions, different ones of populism. We have right or left-wing populism, we have democratic or authoritarian populism, and also an inclusive or exclusionary populism. And when we study the historical periods of populism in South America, it's very interesting because these very and different moments in the history of the region illustrates that variety of dimensions of populism and rejects this bad reputation of the populist phenomena that is presented still today, even in the academic sphere. The literature identifies four main political populist moments in the South American history, and I will not describe them in details, but just to have a general idea, the classical populism that emerged in the decade of 1930s was a left-wing populism, very centered in the figure of the state, a welfare state, and promoted the social and political inclusion of popular sectors of the population. On the contrary, neo-populism that emerged in the region in the decade of 1980s and 1990s was a very different phenomenon because he was defending neoliberal economic reforms. So it's a very clear contrast between classical, a left-wing populism, and neo-populism in the 1990s, that was a right-wing neoliberal kind of populist strategy. And when we see afterwards, in the beginning of the 21st century, the emergence of the so-called revolutionary populism that emerged in countries like Venezuela, Bolivia, and Ecuador, we see another wave of populism in the region, a radical one, a radical left-wing one that promoted socialist democracies in the region and was a firmly criticism against the neoliberal reforms that was conducted in the 1990s in the region. Governments like of Hugo Chavez in Venezuela and Evo Morales in Bolivia, they were radical, revolutionary, populist governments. And more recently, we have another wave of populism here in the region, which is the far right-wing populism, of which Bolsonarism in Brazil is the main example, that is totally the opposite of the revolutionary populism of the beginning of the 21st century. It promotes authoritarian politics, far-right politics, and also represents an exclusionary kind of populist strategy and rhetoric. I will come back to Bolsonarism later, but it's important to say that despite all this difference, all these movements, all these populist movements and regimes share the common intrinsic features of any populist strategy, which are a high concentration of power in the executive branch, a political, very strong and charismatic leadership, and also an anti-elite rhetoric that is present in all these kinds of populism in South America. Populism has a direct relationship to constitutionalism. In fact, the Constitution plays a major role in the populist agenda. Populism can instrumentalize notions like constitutional identity, constituent powers, in order to achieve its political goals. And populism does that by means of an antagonistic rhetoric. That is to say, populism claims that there is a clear contradiction between the people, this imaginary, unique and cohesive majority and mass of individuals, and the institutions of liberal democracies, notably non-elected institutions such as constitutional courts. So populism claims that there is an antagonism between the people and those institutions. And why? Because these institutions are formal, they represent the elite power, and they defend a way of a vision of the Constitution, or better saying, they defend these institutions a constitutional identity that does not represent the real will of the people. In consequence, populism offers a new constitutional approach or a new constitutional project that will explore the major failures of the constitutional liberal democracies, such as the lack of effective political representation, this distance between people and politicians, and also social inequality. The problem is that this populist constitutionalism, this new way of defending the Constitution that is claimed by the populist strategy, is not always of a democratic nature. Sometimes it assumes an illiberal nature, because it will defend that the constitutional identity is represented only by a cohesive majority of people and excludes other individuals, other ways of doing politics, other social groups. So that is the case of Bolsonarism in Brazil. Brazil faces today, and better saying, has been facing a political crisis since 2013. We have a polarized society with a high distrust against traditional politicians, and Bolsonaro has taken advantage of this political vacuum and won the 2018 presidential elections. And it's without doubts that he won these elections defending a populism regime with authoritarian characteristics. Why? Well, Bolsonaro employs an anti-elite rhetoric. He employs an anti-corruption rhetoric, but this is he has this in common with other populist regimes. What characterizes Bolsonarism as an authoritarian populist regime? He disrespects minority rights, the press, information, the liberty of information, the science during the COVID-19 pandemic, and the independence of the judiciary, especially the Constitutional Court, the Brazilian Constitutional Courts. Moreover, he promotes dismantelation, this social regression regarding social rights through ultra neoliberal reforms and economic measures. And he won the elections, in fact, by defending a reactionary agenda contrary to minority rights, with subjects like criminalization of abortion, the flexibilization of gun ownership, the reduction of the age of criminal majority. However, in practice, he has difficulties to implement this agenda. And why? Because he does not have the political support in the national parliament. The Brazilian constitution is rigid. That is to say, to amend, to modify the constitution here in Brazil, the president needs a very high majority of the votes in the national parliament. Furthermore, Bolsonaro, in order to rule, to govern, he needs to implement his agenda. He needs the support of the majority of the congressmen and women in the national parliament. And he has never been able to form a solid majoritarian parliamentary support. That's the reasons why he cannot implement his reactionary agenda. A very similar case we see in Peru under Castillo's populist government. Populism in Peru, like in Brazil, is a historical, persistent phenomenon that traditionally the populist leaders in Peru are originated from the middle class or from very rich sectors of the society. And Pedro Castillo, who is the current Peruvian president, is an important exception because he is a rural school teacher, a true campesino, and he won the elections that occurred in April of this year in Peru. He won the presidential elections by defeating the daughter of Alberto Fujimori, who is a former president in Peru, who has ruled the country for 10 years under a populist, authoritarian, and neoliberal regime. So it was a very significant episode, the victory of Pedro Castillo in the last presidential elections. He is a populist politician, he's a left-winger, he defends the economic policies centered in the state. He defends, for example, the nationalization of the mining sector, the Peruvian mining sector, which is the basis of the Peruvian economy. He promotes social justice, and he also wants to call a popular referendum to elaborate a new constitution. But regarding human rights, he presents a conservative agenda. During his campaign, Castillo has spoken against abortion rights and also against the same-sex marriage in Peru. So Castillo has these initial similarities to Bolsonaro regarding human rights agenda, but I will deconstruct these similarities in my conclusions. But what I would like to point out here that Castillo faces the same difficulties that Bolsonaro faces regarding the implementation of his agenda. And because, likewise, because of two main features of the constitutional design in Peru, the constitutional rigidity. The Peruvian constitution is hard to be modified. The president needs the majority of the votes by the congressmen and women. And also, like in Brazil, Peru has a political system that we call it coalition presidentialism, in which the capacity of the president to govern depends on the formation of a coalition government with parliamentary majority. And Castillo, since the beginning of his government, cannot manage to get this majority political support in the National Congress. He faces indeed a very acute political crisis because the National Congress is controlled by the opposition. But the main difference here between Castillo and Bolsonaro, that is recently Pedro Castillo has showed himself open to compromise himself, to form a coalition government to secure his governability. He compromised himself with the respect of human rights. He compromised himself not to promote a social regression in respect to LGBT population rights and women's rights. And on the other hand, Bolsonaro is an inflexible politician. He does not give up of his reactionary agenda. So as conclusions, I will answer the two questions of my paper. First, how these populist governments address human rights issue? Both of them, they don't have a open, progressive position towards human rights, especially towards women reproductive rights and LGBT population rights. But in practice, they present different political attitudes. Castillo shows himself to be open and compromising, and in turn, Bolsonaro shows himself to willing to impose his agenda by force and intimidation. And the second question, if these governments are successful in implementing their agenda under the current national constitutional structure. And as we saw, they have major difficulties, and it's a very similarity, very important similarity between Brazil and Peru, because both presidents faces difficulties implement their agenda because of the constitutional rigidity and the coalition presidentialism that operates as real barriers against unilateral unconstitutional moves by the executive. I thank you for the attention, and I look forward for the discussion. Thank you.
Thank you, Dr. Elnora. That was very wonderful presentation and precise and on time. So it's time for further discussion, for taking questions and some concerns, comments. The floor is yours. So you may unmute and speak one at a time. So go ahead, unmute and speak. I think I may share my view on populism and may leave Dr. Eleonora to comment on it. Recently, we are also seeing such populism wave in Africa. So politicians, they tend to use this some nationalistic rhetoric to secure the power. And I also follow the situation in South America, especially Peru, Brazil, and in some cases Venezuela is also on the news every time. So how do you see the politicians who argue that they can take populism as the way of reaching to the public to secure power, and they tend to claim that they are working within the ambit of the legal framework. They are not they claim that we are not doing anything bad to the legal institutions or the legal framework. So what's wrong with us if you go to the public and taking some very concerned ideas which the public will be joyfully engaged in? What do you say?
Thank you for the comment, and the question is indeed, and I follow also the movements, the populist regimes in Africa, and also in Eastern Europe. There is a very important wave of authoritarian populism, and this national discourse, well, this rhetoric based on nationalism is very characteristic of authoritarian populist regimes, because one of the main feature of populist leaders, in order to control the mass, or at least the majority of the people, is to put always a figure, an image of an enemy. This is the common enemy logic that is traditional of every populist strategy. So an enemy can be an immigrant, can be a financial crisis, can be a political crisis, can be the COVID-19 pandemic. And when the populist politician is very talented in the rhetoric, he can instrumentalize this crisis or this common enemy in order to achieve political goals. So this is not a new phenomena here in South America. Since the 1930s, this common enemy as the financial crisis, as the foreigners that come to take away jobs and to distress the economy, is a very common weapon in favor of populist regimes. The thing is that I answer and examining the problem here regarding Brazilian law. What can we do? What, or better saying, what can the law, the legal system can do, be prepared against these authoritarian populist threats? He can exactly build a system of constitutional rights and guarantees rigid. For example, in Brazil, we have our Carta, our list of fundamental rights foreseen in the Constitution. And even the president, if he wants to abolish, to strip out a fundamental right of the Constitution, he cannot, because it's a protection as an internal clause. If he wants to concentrate most of the power, political power, in the executive branch, in the treatment of the judiciary and the legislative branch, he cannot, because our constitution is overprotected. So we have many mechanisms here under Brazilian law and in Peru also that protects our constitution and our basic rights against these authoritarian populist threats. But the threat is always there. So I think it's also very important to mystify, to undermine these populist movements by also bringing the population information and more information towards what is a crisis, what's the effects of a crisis, how can a financial, a political crisis affect the country. I think in this case, the press and the academy, they play a very important role to inform more and more the population not to be manipulated and instrumentalized by these populist regimes.
Thank you, Dr. Elnora. Still, we have 1 or 2 minutes before giving back the mic to Dr. Elnora for final thoughts. If there is question or some comments, you can unmute and speak. I think the presentation was very precise and very clear, so that's why we are not puzzled with questions or any comments. So I'll leave the floor once for Dr. Elnora to make a final remark, just in 1 minute.
Thank you. I thank you for all of you for the attention, and I'm available afterwards, after the symposium, through my email to receive some comments. You that are interested in populism, and I think South America can really contribute to the theorization and theoretical discussion on populism very well, because of the variety of populism, regimes, and movements that the region presents. I am available to respond to the comments or to give some lecture and reading recommendations. And I thank you very much once again for the opportunity. Thank you.
Okay, with that, we conclude our first issue on populism and constitution in Brazil and Peru. So now we'll move to the second issue, which is a clear pathway for acknowledging native phase followers' rights through the Constitutional Court decision. And it is carried out by multi-authors, Rofi Washna, Ahmed Habib Al-Fikri, and Faris Agustina, all from, I think, University of Negeri Semega in Indonesia. Again, please forgive me for this mispronunciation. I still claim that this I came from different mother tongue, so I may be annoying some of you. Please forgive me. So let me say few words about the presenters, and we'll leave the floor for the presentation. So we have Dr. Rofi Washna. She's a lecturer of law at the same University Negeri Semega, in Indonesia. She engaged in teaching courses such as agrarian law, forestry law, and constitutional law, procedural laws. So we have also Faris Agustina, again, student from the same university, and she, as you may see from the resume, she is very active in national and so many international activities which held in Vietnam, Indonesia, and across the globe. We have also Ahmed Habib Al-Fikri, the same faculty member of University of Negeri Semega, Indonesia, and this two fellow students are very actively engaging in this national and current agendas of the maybe happening at national level and some international level. In the case of Ahmed Habib, you can see his engagement in the papers and issues on reflection on implementation in the COVID-19 pandemic period. So again, we have 20 minutes for the presentation, and you may share as you may like it, and we'll take the remaining 10 minutes for discussion. So I'll leave the floor for the presenters.
Hello, sir. Can you hear my voice?
Yes, we can hear you. You may continue.
Okay, thank you. Morning, everyone. So it's an honor to be presenter in the Symposium International 2021. My name is Faris Agustina Rahmawati. Let me introduce my team. For the first order is Mrs. Rofi Wahanisa, but she cannot attend today. And the next order is Ahmad Habib Al-Fikri, student of Universitas Negeri Semarang. For our research title is A Clear Pathway for Acknowledging Native Faith Followers' Rights through Constitutional Court Decision number 97/PUU/XYZ/2016. Okay, maybe we can move to the next slide. Okay, this is what our research has been looking at. In the 1945 Constitution Article 1, Paragraph 3, which reads, Indonesia is a state of law. The concept of the rule of law basically holds the principles of protecting human rights. As stated in Article 28, Paragraph 5 of the 1945 Constitution, it states that the enforcement and protection of human rights is in accordance with principles of democratic rule of law. Various ethnic groups, customs, and religions in Indonesia as explained in Article 29, Paragraph 2 of the 1945 Constitution, that the Indonesian has guaranteed every citizen to embrace a certain religion according to their respective beliefs. That, in fact, even though the state has guaranteed the right to believe, in fact, various human rights violations often occurred to the community and indigenous people, especially to the believers. Whereas the current reform era, it can be a momentum that can eliminate all forms of discriminatory rules. What we know today is law number 23 of 2006 concerning population administration. This arrangement is seen as a step and solution to overcome the problems of discrimination in Indonesia. To realize the constitutional rights, both the right to embrace a religion or belief that is owned by every element in Indonesia, plural society, and other rights, a state institution that can realize this is formed, namely the Constitutional Court. One, the result of the struggle and effort to fight the constitutional rights of Indonesian citizens through the Constitutional Court's decision, which focuses on the beliefs of the Indonesian people or beliefs. Seeing these problems, the Constitutional Court, in an effort to fulfill constitutional rights, has an important role, especially for constitutional judges who are expected to be able to apply structural alignments and law enforced in society. The purpose of this study is to find out more deeply how the Constitutional Court carry out its function as guardian of the Constitution, interpreter of the Constitution, protector of human rights, and protector of democracy. For our research method, in this research uses legal research method, with the type of research used is normative judicial. The approach taken in the paper is a statutory approach. Okay, maybe you can move to the next slide.
Okay, thank you. In this slide, I will explain about the conception of the rule of law. The rule of law is a new discourse when viewed historically. Along the way, it has progressed toward the expected change. There are several legal figures who have talked about the concept of the rule of law. For the first, Plato, an idea about the creation of the ideal state from eliminated to figure of the leader who oppresses his people, and through this talk, justice will be created. And then about Kant, Kant has indicator in the rule of law, namely the protection of human rights and the division of the power. It departs from the rule of is in absolute power. Kant indicator is used as a reference that can achieve people's welfare. And then Julius Stahl, the purpose of the rule of law to protect human rights, limit and share state power can be manifested through the enactment of statutory regulation. They added that there is an administration court within the rule of law to try the government, the violation of human rights of the people. The decision of the rule of law will lead to equivalent space known as two terms, namely Rechtsstaat and the rule of law. This explanation then raises question about the concept of the rule of law is held and implemented by Indonesia. Indonesia has a unique legal state concept with its own characteristics that are in accordance with the spirit of the nation. Based on the philosophy of Indonesian nation, it was later known the Pancasila legal state. Although it cannot be denied that there are some similarities with the concept Rechtsstaat and the rule of law. The parameters of the rule of law in Indonesia can be seen from the preamble and the article, the 1945 Constitution of Republic Indonesia. These two parameters contain distinctive values and basic principles, legal ideas, and state goals that can be used as legal political footing. Thank you. Next slide.
Okay, for the existence of the authority of the Constitutional Court, From the history, the establishment of this judicial institution is based on the Third Amendment to the 1945 Constitution of the Republic Indonesia. By the time Indonesia established the Constitutional Court in 2003, there were records of 78 countries that had established the institution. The Constitutional Court of the Republic Indonesia was formed in 2003 in conjunction with the enactment of the law of the Republic Indonesia number 24 of 2003 concerning to the Constitutional Court on August 13, 2003. This continued with the election of constitutional justice through the decree of President of the Republic Indonesia number 147 M of 2003. For the authority of the Constitutional Court has the authority to adjudicate at the first and final levels whose decisions are final for, examine the law against the Constitution, to decide on disputes over the authority of the state institution whose powers are granted by the Constitution, decide on the dissolution of political parties, and decide on disputes regarding the results of the general election. For the function of the Constitutional Court, there are three. The first, when the Constitutional Court functions as guardian of democracy, the protector of the citizens' constitutional rights, and the protector of human rights. Okay, next slide, please.
Okay, this slide about believers in Indonesia. Indonesia is a country rich in cultural and religious diversity that has existed for hundreds of years before independence. Beliefs from religions that exist in the local community are called believers. The word belief, according to the Big Indonesian Dictionary, means an understanding that recognizes the existence of good Almighty, but it's not include or not based on the teaching of one of the 5 official religions. And then about testing of the actual law, the believers. Law of the Republic of Indonesia number 23 of 2006 concerning population administration set limits on the appreciation of belief because isn't the same a religion. This can be seen in Article 64, Paragraph 2, which reads that information about religion as referred to in Paragraph 1 for residents whose religion has not been recognized as based on the provision of law and regulation or for adherents of beliefs is not filled in, but it is still served and recorded in the population data. For this reason, the petitioners Ngarang Mehang Tana Pagar Damanra Sirait Arna Puba Karlim were represented by their attorney. The petitioners submitted a judicial review to the Constitutional Court number 97/PUU-XIV/2016 on Article 61, Paragraph 1 and 2, and Article 64, Paragraph 1 and 5 of the Law of the Republic of Indonesia number 24 of 2013 concerning amendment of the Law of the Republic of Indonesia number 33 of 2006 concerning population administration. In their petition, petitioner argued that the word religion on Article 61, Paragraph 1 and Article 64, Paragraph 1 is contrary of the 1945 Constitution of the Republic of Indonesia and doesn't have legally binding conditional as long as it doesn't include adherence of religious belief. And then how about the decision of the Constitutional Court? In its decision, the panel of judges in case number 97/PUU-XIV 2016, the panel of judges was of the opinion that word religion in Article 61, Paragraph 1 and Article 64, Paragraph 1 is contrary to the 1945 Constitution of the Republic of Indonesia and has no legal force to bind conditionally, as long as it doesn't include adherence of the belief system. In addition, the panel of judges also state that Article 61, paragraph 2 and Article 64, paragraph 5 contradicted the 1945 Constitution and Republic of Indonesia and didn't have binding legal force. In the decision of the Constitutional Court, juridically, it can be a legal basis for believers or of faith to get recognition, respect, and protection in the form of embedding their belief on EKTP or electronic identity card. Next slide.
A description of the function of the Constitutional Court in the judicial review of the Aqua Law. The Constitutional Court decision number 97/PUU/XYV/2016 states that believers of class have the same rights in the inclusion of population data elements in the form of inclusion of their beliefs, namely in the document. The Constitutional Court decision is judged by the legal experts and the public as a decision that will carry broad legal implications and can lead to pros and cons. Through the Aqua decision, the Constitutional Court has overseen the contests that depend on the 1945 Constitution of Republic Indonesia, which guarantees the constitutional rights of its citizens to be able to embrace their respective religions and to worship according to their religion and beliefs, as stated in Article 29, paragraph 2. As for the function of the guardian of the democracy through the Aqua decision, it also provides space for believers to be able to exercise their rights in the political realm, such as voting and being elected. Shows that it's really important for the state to protect and enforce the guarantee of freedom of religion or belief without discrimination for every citizen. The Aqua decision reflects that the Constitutional Court has also carried out its function as the final interpreter of the Constitution, but has also carried out other functions, such as guardian of the Constitution, the guardian of the democracy, the protector of citizens' constitutional rights, and the protector of human rights. Okay, next slide.
Okay, and then how about the implication of the Constitutional Court decision number 97/PUU/XIV/2016? This decision is at least a starting point for explicit legal recognition in the legal system in Indonesia to legal status of people who believe in religious belief. Prior to this decision, believers in living in a variety of discriminatory state policies and some of their civil rights couldn't be fully enjoyed. The most important point of this ruling is the obtaining of the constitutional right of believers, especially in the field of writing their religious identity. In the judge's consideration of the decision of the Constitutional Court Aqua, that the term religion isn't at their head. So in Article 61, paragraph 1 and Article 64, paragraph 1 of the Population Administration Law includes belief. So by itself, the norm of the law provides certainly that they are not followers recognizes religion in accordance with statutory regulation. The juridical consequences of the erga omnes Constitutional Court's decision, apart from providing remedies for injustice condition that must be abolished immediately, also provide a critical evaluation that the field of life of the defaults hasn't been properly protected. There is a need for a law that specifically regulates freedom of the belief for believers in good Almighty. Its function carried out by law as a regulatory mandate in the field of constitutional material, which includes the relationship between the state and citizen, and between citizen or residents as a whole reciprocal. Thank you.
I think we come to the end of the presentation. Am I right?
Yes, sir.
This means the floor is for us, the participant. So now you can share your thoughts, comments, and questions if you have, and you may unmute and speak.
And Yomara, may I?
Yes, yes, please.
Okay, thank you very much. Should I turn on my camera or is it fine for me to turn it off?
We are okay. Just continue.
Okay. So, okay. Thank you very much for the opportunity. So my questions to the presenter, I would like to know the response from the government regarding the ruling from the Constitutional Court, whether the government consistently follow up the court or they try to modify the court decisions in a way. Thank you. That's my questions.
Okay, so Farouz or Ahmed, you can proceed.
Sorry, sir, can you repeat your question slowly, more
Okay.
slowly?
Okay, so I think your presentation is interesting because you try to explain about the court decisions regarding the traditional believers. My question is with regard to the implementing agencies, which mean how actually the reactions from the government regarding the court ruling, whether the government then immediately follow up the court ruling or the government try to delay or even to modify the when they implement the court ruling. Is that clear?
Okay, let's discuss this.
You good?
Yes, sir.
Oh, are we expecting Ahmed to comment or? Of course, the executive organ will be in much tight position to enforce such court decisions. That's what I think Mr. Andy Omar was referring. How would expect the reaction from the government side on implementing these court decisions? I think Mr. Andy Umar, you can give us your insight so we can further deliberate on the issue.
Okay, but because I think when we look at the court decisions, the court can basically declare everything about the law. But the thing is, the court stop when they declare the decisions, right? Because the implementations of the court decisions would be another branch of government. In this case, sometimes the government or the implementing agencies immediately follow up the court decisions if they believe that the court decision is actually in line with their agenda. But sometimes they try to delay the implementations of the court decisions if they think that it impact is significant for the government. For example, it costly, or it has like significant impact to the administrative staff. So I wonder whether in these decisions the court the government as the implementing agencies of the court decisions promptly execute the court ruling in this case, or the government try to quote unquote negotiate how actually to promptly implement the court decisions in government's way. Because in my understanding, when we talk about the identity card, we know that in Indonesia so far we have 6 official religions acknowledged by the government. But we also cannot neglect that we have traditional belief, which actually exists in Indonesia far way before the existence of the 6 official religions in Indonesia. That's why the questions for the presenter is very important, because how can we recognize the 6 different religions which come later, and we do not recognize what we call the native religions that already exist in Indonesia far before the existence of before the coming of the 6 official religion in Indonesia. My understanding is that they try to quote unquote modify by showing 2 different identity cards. The first card is actually expressly mentions religions and then name the religions: Islam, Christians, Hinduism. And then the second identity card showing what we call the traditional belief, penghayat kepercayaan. The tradition, what we call penghayat kepercayaan, means the native belief, that kind of thing. So instead of putting together in one single identity card, they put 2 different identity cards. That's my understanding. That's why I try to confirm whether my understanding is correct.
Okay, as long as we know, there are still points about this decision, that the Constitutional Court has already issued a policy regarding this issue. There are several efforts that can carry out by the government as a follow-up the decision of the Constitutional Court number 97, related emptying the religion column for followers trusting electronic ID cards. First, the government needs to do clear data collection on adherent beliefs that have existed so far. If that not done, it is feared that it will become a new problem when there are citizens who profess to have a certain belief which is not clear and doesn't match Pancasila and the 1945 Constitution of Republic Indonesia. Maybe my partner can explain more about this question.
Then that will be fine if Ahmed join. But I think it's fair to say that if there are some administrative costs, the government will look into its budget and may force it to reschedule or do some programming. I think it's also fair to say that this agenda needs a further follow-up study on how the government is implementing this current decision of the court.
Okay. I think, however, specifically for this third step, through follow-up in the form of change to actual law is the most ideal legal choice to follow up on a decision of the Constitutional Court. But in this case, according to the urgent to do because not too much substance norm which need to receive in administrative law. Without making change to the that law, the government has been able to follow up the constitutional court decision by doing adjustment to policies and regulation rules related to the population administration exist in various implementing regulation that exist all this time with attention the result of the interpretation of the constitutional court. I think that's enough. Thank you.
Okay, yeah, we still have 2 minutes for this specific presentation. So I will give you 1 minute if you have anything to add on this. Perhaps the discussion will go on even after the this panel is set up.
Hello, sir. May I ask a question?
Yes, please. Let's speak.
It's just a general question that whether Indonesia government recognizes some religion as the state religion. Just general question. Like in India, we have the government has no religion or of its own, or it's known as secular government. So, and for example, in Pakistan, it's a Muslim country. So I want to know about Indonesia, whether it has some state religion. Just a general question.
Iris, you may continue. I think the question is...
So your question is,
whether
the country has religion, right?
Whether Indonesia is a secular state.
Actually, country has no religion, but there are some religion from their citizens.
So yes, there are religions recognized under the state, and as Fairuz claims, the Indonesian government is secular. I mean, the Indonesian state is secular state. With this, we conclude this topic, and we'll be going forward to the third issue. So,
excuse me, may I?
Yes, sir, please.
So sorry to be asking this question or making this intervention towards the end, but I still feel I'm not, to be blunt, I am not satisfied with the answers given by the presenters to Professor Omara's question. I mean, and I feel that the question is germane to their paper, and personally, I feel dissatisfied with their answers. However, I think to, obviate wasting more time, probably they will maybe put a write-up or something to tell us the position of things. Because I repeat, that question is germane to the topic they presented, and giving a shambolic answer or answers cannot be, acceptable. We want to be educated by the presenters. Thank you.
Yeah, I think we leave the specific segment, hoping there will be follow-up study how the government will respond to this court decision. I hope we'll see Fairuz and Ahmed in coming panels with further studies. So,
may I give my final comments on the secular or not?
I think it's okay. Please just be
Okay, thank you, man. It's very short comment. So Indonesia is basically neither secular nor Islamic country, because we do not specifically stated that Indonesia is Islamic country, even though we have a majority Muslim in the country. But when we look at our constitutions, we may say that we acknowledge the existence of God and we give freedom to everyone to pray, to worship to God. But we do not state a very clear, specific, particular religions. That would be my comment. Thank you very much.
Thank you. So
thank you, sir.
With this, we'll go to the third session. I mean, the third topic, which is on recognition of forest carbon rights in Indonesia based on the constitutional approach. It's done by Kenny Setfa from World Resource Institute of Indonesia. And let me say a few things about the presenter. He's an independent researcher focusing on environmental law. He's affiliated with the World Resource Institute of Indonesia, and recently published this working paper on how would identification technologies help ensure timber legality in Indonesia. Issues with carbon rights, I think, is most contemporary agenda when it comes to the climate change agenda. So I'll give the floor to Ken Serfa, and you have 20 minutes for the presentation, and we'll proceed with discussion and questions with the remaining minutes. The floor is yours.
Thank you, Mr. Goitom. I would like to share my screen first. Can you see the presentation?
Yes.
Okay, thank you. Good morning, everyone. My name is Kenny. In this opportunity, I would like to present the findings of my paper, which is for the symposium, which is, and the title is the Recognitions of Forest Carbon Rights in Indonesia based on the constitutional approach. A little bit about the background of my paper. The regulations on forest carbon rights in Indonesia, in my opinion, is essential due to the emergence of market-based mechanism to control climate change and the forest-based or the forest-based emissions. And this mechanism incentivizes anyone, it could be the state, organizations or legal entity, and even individuals who contribute to maintain the forest functions, or in simple words, keeping the trees intact because the carbons are stored on the trees or on it. And one of the notable market-based mechanism is called REDD+, which stands for reducing emissions from deforestation and forest degradation, plus conservation, sustainable forest management, and enhancement of forest carbon stocks. REDD+ was negotiated under the UN Framework Conventions on Climate Change, or the UNFCCC, and over the past decade, and was endorsed again under the 2015 Paris Agreement. Through REDD+, developed nations can provide financial incentives to developing countries for reducing forest-based emissions and enhancing the carbon captures and storage functions of forests. In other words, the developing countries can receive some sort of a payment for verified emissions reductions, which can be financed either from the public funds and also the voluntary carbon markets. Under this REDD+ program, Indonesian government itself has concluded a deal with, for instance, the Norwegian government to reduce deforestation and forest degradations, which worth around $1 billion US. And the issue is in here is that there is a tendency showing that the incentives of REDD+ shall only be distributed to those who own legal title or land rights. In Indonesia itself, there are still numerous overlapping claims on forest title between the state and also forest communities. Administratively, the Indonesian government divides the legal status of land into two, which are the forest estate, or maybe in bahasa is kawasan hutan, and also areal penggunaan lain in bahasa is other use areas. And the size of forest estate itself, or the kawasan 0.9 million hectares, or 63.7% of the total size of Indonesian land. The Indonesian law does not allow the issuance of land rights in forest estate, yet it was reported that approximately 9.2 million families live in forest areas, and 1.7 million of them were category miskin. And to claim the rights of benefits in market-oriented incentives like RED+, it is essential to establish that they have these property rights to the carbon sequestered in forests, or the right to benefit from activities that lead to carbon storage and carbon sequestrations. Carbon as a tradable commodity needs to be defined clearly to attract capital from the private sectors through carbon market, so it can be bought and sold without the ambiguity. Next, basically, how to access the forest carbon benefits or incentives, such as the RED+ program under the Indonesian law. There are at least 4 types of permits which are in this table, as stated in this table, which are environmental service licenses, or in bahasa is jasa lingkungan, social forestry licenses, and ecosystem restoration concessions, and forest carbon administration permit. This permit is actually integrated and attached to concession licenses, like the above 3, like environmental service and also social forestry licenses. So the applicant does not need, in principle, does not need to apply for different permits once they've got the concession license. These permits targeted different stakeholders and have different legal bases. For instance, like environmental service licenses, the targets both the private sectors and forest communities. And for the social forestry licenses, it target only the forest communities, while ecosystem restoration concessions target private sectors. And the last one, the forest carbon administration permit, it targets various stakeholders, is private sectors, forest communities, and even the forest management unit, or in bahasa is Kesatuan Pengelolaan Hutan. Is basically a regional government institutions who work to monitor the forest in under the regional government in Indonesia. It can be inferred from this that the access of carbon was managed under the permit or license regime, or in bahasa izin, instead of rights or the hak in bahasa. This applies on both forest estate and also the other or the APL, since the individual landowners should obtain license to trade the carbon. One of the distinct features between the license and rights were that rights under agrarian law is it is transferable and can be used as a collateral. My next research questions from this, my next research question is, will assess whether existing legal framework on carbon rights has been in conjunction with the constitutions as the supreme law in Indonesia. The discussions will emphasize on the Article 33 of Indonesian constitutions as the umbrella provisions underlying the state authority to control natural resources in Indonesia. from the provisions, there are at least three wordings that can be inferred. That first of all, like the state control, and then the sectors of productions which are important for the country and affect the life of the people, and also the greatest benefit of the people. The wordings like in quote like the under the powers of the state on sub article 2 and 3 of the article 33 of the constitutions implicate government authority to control natural resources in Indonesia. The threshold to determine whether Indonesian government could exercise its rights to control particular natural resources should be asked whether such resources is like important for the country and affect the life of the Indonesian people. In practice, most of natural resources acts such as like acts governing the forests, minings, oil and gas, etc. states this wording on its considerations parts or considerants dalam undang-undang of the to execute the what we call in Indonesia is hak menguasai negara or the state control rights. State control rights is not similar with the concept of the ownership under the property rights, since the state does not like literally own all the natural resources commodities, but it has the authorities to handle, regulate, manage, and supervise. Using the basis of Article 33, several acts pertaining to natural resources governance, such as the Act number 7 of 2004 on the management of water resources, Act number 22 of 2001 on oil and gas, Act number 20 of 2002 on electricity have been challenged on the Constitutional Court by various community groups. And from these, from some of the Constitutional Court decisions, I infer some points that the Constitutional Court perceived that it is not always wrong for not granting individual property rights against a particular commodity. This was recognized despite the recognitions of basic individual rights under the constitutions. For instance, Constitutional Court decisions number 3 of 2010, one of the legal issues discussed is the notion of the coastal water management rights. In bahasa is hak pengusahaan perairan pesisir, as formed by Act number 27 of 2007 on the management of coastal areas and small islands. The concept of the coastal water management rights as rights or hak and not a permit could have potentially transferred the rights to private domination and deprive the state control rights or the hak menguasai negara. Without the proper safeguard, the court is on the opinion that the rights was being more favorable to private sector and could have diminished small fishermen and local coastal communities. The similar perceptions emerged with the water concession rights or hak guna usaha air as regulated under Act number 7 of 2004 on water resources. In the Constitutional Court decisions number 85 of 2013, the court ruled that the state must fulfill the people's water rights and delegate the business to the state-owned enterprises and also regional-owned region-owned enterprises first before granting concession rights to private sectors. And in Indonesia, the state control rights or the hak menguasai negara is limited to the principle of the greatest benefit of the people, or in bahasa is like sebesar-besar kemakmuran rakyat as mentioned under the Article 33, sub-article 3 of the Constitutions. The Constitutional Court elaborating this principle further, which consists of four main elements, which are the first, the benefits of natural resources for the people. Second, even distributions for the people. And third, the participations of people to determine the benefit of people. And the fourth element, the last one, is the tribute to the people hereditarily in using the natural resources. Thus pertaining related to the carbon rights communities, I think the implementations of state control rights shall adhere to these four elements. As discussed on next slide, sorry. As discussed on the previous slides, existing laws in Indonesia allows the peoples and forest communities to enjoy the benefits of carbons through licensing procedures such as environmental services, social forestry licenses, and ecosystem restoration concessions. However, it is noteworthy that to consider the state needs to consider the compliance abilities of the forest communities, since these licenses require them to pass various administrative and technical procedures, such as creating working map, making resources inventory, making production reports, etc. In practice, the communities were unable to comply with all of these procedures without the help of the third party. Usually it will be the civil society organizations and even international donors. And after the forest communities have gone through a lot to obtain these license, and the state needs to protect their rights from overlapping concession claims and forest encroachments. For instance, just to give you some backgrounds, it is expected that there are around 3.4 million hectares of oil palm plantations in the forest areas, forest estate, or the kawasan hutan, mostly located, for instance, in the Kalimantan and also Riau province. And under the Indonesian law, actually, the oil palm plantations licenses would not be issued on the forest estate because it only can be used. It can only be issued on the APL or the other use areas, with various overlapping land claims and licenses on forest estate. The forest communities support to protect their forests and store carbon are threatened by extractive concessions and also some like illegal loggings and illegal encroachments of forest estate. Because basically on REDD+ program and carbon sensitive programs, you need to maintain the trees and also the forest intact. Actually, the government has actively initiated one map policy or kebijakan satu peta to integrate all these overlapping claims and maps and binder-based conflict resolutions in all Indonesian region. Hence, the state must present to increase the capacities of these forest communities and also their knowledge to perform technical requirements of these carbon storage activities, such as, for example, on their working area. For instance, in an NGO called MBO, work together with farmers and provide them with trainings on standard forestry methodology to manage a project of Mexico. This project was financed from voluntary market. Thus, Ambio received benefits, acting as the broker to sell the carbon stock. In a program such as REDD+, in which Indonesia or the state has more interest at stake, the Indonesian government should emulate the same approach to involve these communities as skilled manpower. And also, since the forest carbon storage and sequestration activities are considered as a new instrument under international law, the state still have to respect the long-standing customary livelihood of forest communities, such as the Sweden agriculture and small-scale logging. Although these practices are not in line with the notion of carbon incentives, such as the REDD+, which requires preservations of forests and natural plants, the government still in international, there are this principle called free, prior, informed consent, or the FPIC, which can be described as the establishment of conditions under which people exercise their fundamental right to negotiate the terms of externally imposed policies, programs, and activities that directly affect their livelihoods or well-being, to give or withhold their consent to them. Without the consent from communities, it is unlikely that RED+ project could sustain and may lead, this may lead to a conflict or inequitable outcomes. At the highest probabilities, the communities can reject carbon project in their area if it affects their livelihood practices and denies access to extractive forest resources, because it's basically their customary livelihood practices.
Okay,
this issue,
Kenny.
Yeah.
Yes, you may add through the question and discussion time.
Okay.
So I can start for saving time. I can start with one question.
Okay.
I said that the law which authorizes the state as sole ownership of carbon commodities is, you claim that this law has somehow infringed these indigenous or communal rights of the public. So if this specific law is against the Constitution, how do you say this is still enforceable against the Constitution, assuming that the Constitution is the supreme law of the land?
Okay. To respond to questions, I'm not in the opinion that the laws infringe the rights of dispersed communities, because basically state control over the forest resources, the sole owner of the forest resources, is basically quite common in other parts of the world also, and also based on the based on the Article 33 of the Indonesian Constitution, the state control rights or the hak menguasai negara is also not similar with the concept of individual, the concept of ownership and the property rights. But I'm in the opinion that in executing that Article 33, there are some like notes or like homeworks for the government, as mentioned in this slides, that needs to be resolved first for guaranteeing the carbon rights of the forest communities to enjoy the benefits, carbon incentive programs such as RED+.
Oh, okay, thank you. Other participants, you may forward questions.
Okay.
I have a question.
Okay.
May I continue?
Yes.
Okay. I want to thank Mr. Kenny for this insightful presentation. Quite frankly, this is my first time of hearing about carbon right and all of that. And while he was making the presentation, I was trying to relate it to my country, Nigeria. And I think I would like to do something about it in the nearest future. I want to ask a question which could also, guide me towards researching on carbon rights in my country. Is it possible to extend such carbon rights or liken carbon rights to socio-economic rights?
Yeah. I think it is possible, but my analysis actually relying more on the maybe like the agrarian law and the property rights. So I did not touch the issue of the social economic rights, but I guess one of the important elements that needs to be adhered around this like RED+ program and also carbon rights is the willingness to participate from the forest communities itself, like as mentioned on the principle of the FPIC, because sometimes I believe that since it is a new concept under the international law, maybe like the communities are not familiar with these practices. So the first thing needs to do for this is to socialize this concept for the forest community. So and tell them what are the benefits on joining this program, because for example in Indonesia they mostly use the Sweden agriculture and also small scale logging for their livelihood. So it's like the government need to socialize this with them.
Okay, Feliz, you may forward your question.
Okay. Hi, Kenny. We're college friend.
Yeah.
So what I want to ask is, I don't know if this is a question or more like a statement, but I think I would like to challenge your categorization of the forest carbon and how you use the Article 33 of the Constitution, because from what I understand, carbon is inside the trees, and it will only, be released into the air if the trees are set on fire or if the forests are set on fire. And the reason why the developed countries have this carbon market is because they are industrialized countries, and even though they might not have as much as what do you call that, just like factories or what have you, like we have over here in developing countries, but they do have like a lot of branches. They have the headquarters, it's over there, but we are the ones who are supplying them with things, and in doing so we need sometimes trees to set on fire. So in short, forest carbon is only becoming a public good, assuming this is what you're saying, that's why you use the Article 33. It's only becoming a public good because there is a commodification of the carbon itself. So it is not in the sense the same with, let's say, when you talked about water concession, because it's clear if it's water, it's for the people. If it's oil and gas, it's for the people. It's like, it's something that we actually use every day. But forest carbon is a commodified entity. It's not really like a natural resources that we can use. Like, I can't burn something over a carbon. I don't know if Kenny gets what I mean, but I just think that I don't know. I just think that like the whole, because like the conference is about like global south, and sometimes like we kind of need to like interrogate the structure of what has been established in front of us, that sometimes we as developed countries can only accept or might not have that much of a political power to really question what the developed countries have talked about in the Doha round or in the UNFCCC. I just think that the carbon market itself is problematic.
Yeah.
Oh, yeah.
Well, to be honest with you, Filza, I'm sort of agree with your statement on the commodifications, because it's actually an instrument that was introduced by international law. But on the one side, that it is quite well, under international, it is quite compulsory for Indonesia to to try to make the system works, because they have also made commitments to reduce deforestations and forest degradations. But this is why I'm sort of agree with you. There's a lot of like technical knowledge, technical requirements that needs to be built under the Indonesian maybe carbon market mechanism, because from what I know, with my interviews also with some of like with my discussions with some itself has not like been well created, and the legal framework for the carbon sales and purchases is still lacking in Indonesia. So there is still a long way to go for this mechanism
I
to work in Indonesia.
I think
So
we have
but
we are
my
losing
point
Kenny,
from
but it's fair since he talked much of the issue. So I think the discussion will follow even outside this Zoom meeting. Again, you may share your contact address, so somehow the academic knowledge could be shared everywhere. Thank you, Kenny. And with this, our time forces us to move to the last segment in our session, which is titled as Falling Down the Rabbit Hole, How COVID-19 Accelerates the Decline of Democracy in Indonesia. It will be presented by Feliza Nabil Avianti from Raul Weber Institute of Indonesia. Feliza, she's a graduate from the prestigious Columbia School of Law, and she worked over 6 years on the human rights sector, and I think she's focusing more on public international law, specifically the international human rights part. So I'll leave the floor for Feliza, and it's yours.
Thank you so much. Wait, let me share my screen. Okay. Lauren. Oh, okay. This is not what I have in mind, but let's just go with this. Is everyone okay, or if it's too small?
It's okay.
I'm good.
It's okay. All right. Thank you very much for the opportunity. I'm very glad that I can present my paper. I genuinely, I'm happy to be here because I find that like there are not a lot of conferences and symposium that want to focus on the global South approach on things. So it's a very it's just very good opportunity to know that an Indonesian university is leading this discussion. So the title of my paper is Falling Down the Rabbit Hole, basically how COVID-19 accelerates the decline of democracy in Indonesia. The keywords is obviously Indonesia, COVID-19, state of emergency, abuse of power, and declining democracy. So this is the outline of my presentation. First, I'm going to give you the brief background and then the research questions I have for my paper, the mini literature review, and then to the main topic of my paper, which is the stuff that I want to analyze, and then conclusion. Now, I'm going to talk about the background. So people have talked about COVID and its impact to economy, its impact to public health, but I found that there are not a lot of discussions regarding how COVID-19 really impacts democracy and how COVID-19 disproportionately impacts the democratic rights of the marginalized people who are historically discriminated, persons with disability, women, children, and elders. And these democratic rights are usually defended through advocacy by communities, human rights defenders, CSOs, and oppositions. So the problem is, since COVID-19 hits, the civic space has been shrinking. Human rights defenders, oppositions, they're intimidated by the government. They're even incarcerated. Protests were also curbed, and dispersed, all in the name of COVID-19. So the main question is, are these security measures genuine or just a pretense for something else? And then I found a report drafted by Asia Center, which I think is very comprehensive. And they coined the term Southeast Asian Government's Crisis Playbook. So basically they have gone back, I think, even like a decade before COVID-19, and they see a kind of pattern 2 decades, a kind of patterns that the government of Southeast Asia have dealt with each crisis that have impacted us. And these patterns are basically, it's almost like a guidebook that the governments use from years to years to handle the crisis and to gain some control, like extra control. So that's why I formulate these 2 research questions. First, why and how the government of Indonesia operates the so-called Southeast Asian government crisis playbook to suppress democracy. And second of all, I think like this one is more, I think personally, like it's really interesting to answer this question. Is COVID-19 a catalyst or just one among many reasons why democracy is declining? The 3 papers that I used to expand my ideas is, like what I said, the report made by Asia Center. The second one is by Marcus Mietzner on populist anti-scientism, religious polarization, and institutionalized corruption, and how they affect the democratic decline of Indonesia. And the third one is by Wasisto Raharjo Jati in PhD Insights. So the first research question, how does Indonesia or the government of Indonesia implement the playbook? What the playbook really is, it's a learned behavior over crises that occur in Southeast Asia for decades. And just and in the last 2 decades, there are a lot of things that are that impacted us. Like, for example, the 1997 Asia financial crisis, the 2001 September 11 US terrorist attacks, and the SARS outbreak, the Indian Ocean tsunami. I would like to go further to explain this, but it seems like there are not enough time. But you will see later in my paper how the government of Southeast Asia use all of these crises to sort of solidify their methods to suppress democracy. So what is inside the playbook itself? First, they will always place an emergency laws and temporary powers to extend the legislations that they formulate during the crises. Second of all, there's always a suspension of democratic activities under the pretense of security measures. Third, there's always going to be surveillance of the citizens with technologies. Fourth, there's a framing of individuals and organizations that pose political challenge. Fourth, there's a post-crisis attempts to extend temporary legislations. And the last one is they always learn from experience to strengthen the measures at the next crisis. So the way the government of Indonesia implement the playbook in COVID time is, first, there's a curbing of the protests. So during the last 2 years, one of the big debates in the politics of Indonesia is, one of them is the Omnibus Law on job creation. But since COVID-19 hit just 1 month after the nationwide protest was organized, the large-scale social restrictions, which restricted the size of public gathering, kind of pressured the human rights activists and people who protests to sort of move their avenue from protesting on the streets to virtual online platforms such as Instagram, Facebook, Twitter, and WhatsApp. But I think it was a successful campaign and advocacy because the effort did brought a lot of traffic and awareness of the relevant issues inside the Omnibus Law itself. Just like a quick preview, the Omnibus Law is like this one giant bundle of law which basically tries to deregulate a lot of the existing laws in Indonesia. Just one of them is the labor law, obviously the human rights protection in the labor law, the environmental rights in the environmental law, and a lot of other things that I think are already, they're not bad, but they're also not that good, but they're okay, but this omnibus law, they're trying to deregulate it to bring back more investments and stuff. So you can see why a lot of people are reacting strongly towards this. So even though the protest moved online, but eventually the bill was passed by the House of Representatives. Another method of suppressing democracy is by drafting laws and policies. So following the outbreak of COVID, the government declared the state of emergency in February 2020. And then afterwards, the Indonesian police force announced a series of internal directives to maintain order during the pandemic. And the police is not exactly friendly towards the opposition either. They tend to use a lot of, like use of force in maintaining order. So that's why like a lot of human rights defenders are like very suspicious of this internal directives. Third, I'm just going to go through this very quick. The erosion of electoral democracy. So during the COVID outbreak, our regional elections was postponed from September to December, and this can be seen as a strategic move to keep the current administration in place for like a longer time. There's also stifling political critics, like the weaponization of Ite law or the law on electronic information and transactions law. The government used this law to basically silence their critics and oppositions. The law itself is already problematic because it tends to I think it just has like a very vague definition of hate speech. So that's why even when people are trying to legally critic the government, somebody can say like, oh, you're doing a hate speech, but you might think that this is funny, but this has happened, and a lot of the people who criticize the governments, actually they're in prison now. So we really have to take this seriously. And a lot of journalists and human rights defenders are actually afraid of the weaponization of Ite law because it produces the imbalance of power. They're against the government, and they tend to self-censor themselves and not doing the great job of the check and balance. There's also an increasing surveillance. So over here, having this crisis, we kind of have to like fill in this application called Peduli Lindungi. Like when you go to like a public space, you have to scan the code, the barcode, and inside the app, you have to fill in your personal information and stuff like that, so that whenever, let's say, you're positive with COVID, the government can track you down. That's basically the whole premise of the app. But it has been proven that it is used to surveil and track the populations, and it has a very high risk of privacy violations. Like, for example, all the information gathered in the app is stored in government database, and there is no clear oversight and clarity on how long the government can keep such information. So there is a huge, what do you call it? It's like potential to, for the government to abuse the information. There's also a problem of funding shifts. So the funding that I'm talking about here is the kind of funding that a human rights organization usually have from like this bigger donors, such as, let's say, open society foundations. So during COVID, they tend to either just like completely not going through with their plans. It's just like, just like scrap it, it's over, we're going to funnel it for something else, or they tend to postpone the project itself, which means that there is the kind of flow of money that used to be stable to these important human rights organizations is now not there anymore. So a lot of human rights organizations have to only have a little to no money to run their operations. So it is very problematic, the use of this playbook. The next one is the second question. So if I want to try to answer if COVID is really a catalyst, or is it just one among many problems? And my finding is that COVID-19 is only the catalyst, but it's not to blame for all of the democratic backsliding. So what I found is that if the state of democracy before COVID is already all right, is already at least stable, when COVID hits, it should not have been in this state of just like despair. So for a country to be able to be sustainably democratic, it has to first have a very strong democratic foundations. So the reason why Indonesia's democracy is this bad is because we don't have that strong of a democratic foundation. And this can be seen from our initial inadequate responses to COVID-19. That is, just like anti-science. It is riddled with just like a lot of other things that I will explain later. Like it's not really a public health response, but it is infused with clientelism, the moral responsibility to not anger the people who have voted Jokowi. So yeah, that's it. I just want to reiterate this really interesting finding is that so the government's initial adequate responses to COVID runs parallel with the erosion of democracy. I hope that makes sense. To further explain, why do I think that COVID-19 is only a catalyst? Because, like what I said, the democracy.
It is my time to be moderator.